Welcome to this presentation. We're covering a portion of Chapter 10, specifically Part 5, the portion of Chapter 10 that discusses requests for admission. As you know, this chapter generally covers the topic of discovery. So let's begin. Let's cover kind of the basics of how requests for admissions work. What is a request for admission? Well, it's a request asserted by one party to another. So we're talking about party-to-party request. And as we've seen in some discovery tools, the tool has to be sent to a party in some cases, for example, interrogatories and requests for admission, and also mental and physical examinations. We've seen other discovery tools that can be sent to non-parties, such as depositions and requests for production. And what a request for admission does is that it requires the party who's received it to admit the truthfulness of a particular statement or the genuineness of a document or the application of law to facts. It is not an appropriate request for admission if it is strictly establishing the truthfulness of a particular proposition of law. The Federal Rule of Civil Procedure that applies is Rule 36, which we'll look at in just a moment. As noted above, we can only propound this or send this to a party. We can't send this to a non-party. And the answers are not going to be sworn, but we'll see that's really no impediment to the effectiveness of requests for admission. And there's no limit to the number of requests that a party can send to the other side. So unlike interrogatories, for example, where there's a cap at 25. So why do people send requests for admission? Well, as we noted before, right over here, one of the big purposes is to authenticate documents, or to confirm that that document is exactly what we think it is, that there's no differing opinion about the authenticness or the genuineness of a particular document. Another purpose is to simplify a lawsuit, to remove the need to prove certain facts and to waste some of the resources of the court and the jury to present evidence about an issue that really isn't in dispute. And also to emphasize particular facts that are buried in the documents. This could be more directed perhaps at a settlement strategy. You want to point out to the other side, hey, we've caught on, we see that this is an important admission. We want you to get the fact that this is important to the circumstances of the case, and maybe we're hoping this will lead to settlement. It's also possible to include in your request for admission the request that a very key fact to the resolution of the lawsuit be admitted. Now, this is a bit of a Hail Mary kind of pass. It's probably not going to work, but if it works, it's brilliant. This would be a situation wherein you say something that if the other side admits to it, basically you've won the lawsuit. Now, of course, the odds of the other side accidentally admitting to it are pretty small. But after all, it doesn't take a lot of effort to prepare such a request. And if they deny it, well, you haven't lost anything. If they accidentally admit to it, or perhaps more likely, fail to respond within the time period, they will have deemed to have admitted that particular statement, and you may well just have won yourself the lawsuit. Is that likely to be how things play out? No, there's very much of a long shot possibility, but you never know. Let's continue on from here. How long do we have? Speaking of the deadline, we have 30 days. This is the same deadline that we've seen with the interrogatories and requests for production. Obviously, it becomes 33 days if it's delivered by some means other than hand delivery. And as we've seen in the other written tools, the parties can expand upon that date, and the court can also change that date. As I've noted before, you need to be sure to calendar this date. Probably more importantly than any other of these discovery tools, calendaring this date is really essential. If you miss an interrogatory date and you're one day late or something like that, the world is probably not going to collapse around your feet. It's probably a fixable situation. But you miss the deadline for request for admission by even one day, it may have very dramatic case effects upon the case. So it's really important that you calendar that date. As it's important to calendar every date, but if you're going to be sloppy with the date, this is not the one to be sloppy with. So when you have admitted a fact, either because you've actually said in the request for admission that you've admitted a fact, or it's deemed admitted because of the fact that you didn't respond, that counts as an admission. That means that you can't change your mind later and say, well, no, we didn't mean that, or that's not what we thought was true, or we thought at one point that was true, but we've since found out it's not. No, it's admitted for all time. And of course, if you miss the deadline and accidentally failed to deny something that you otherwise would, we call this a judicial admission. And what is a judicial admission? Well, it's a statement that has been admitted and it cannot be contradicted later on. So obviously, be careful about those dates. Really important in this context. Okay, so before we go ahead and look at the format for how to prepare a request for admission, let's flip over and look at the actual Federal Rule of Civil Procedure that applies to this particular circumstance. So here we go. We're going to go down to Rule 36. You can see it's called Request for Admission. And here we have the sections. We have Roman numeral A, I guess it's not really Roman numeral, it's letter A, which talks about scope and procedure. And then we have section B, which is effective at admission or withdrawing or amending it. So let's look at these for just a second. Okay, so what is the scope and procedure? Well, the scope says a party may serve on any other party. Okay, let me just flag that. That's that key idea that we were talking about a second ago. You can't send this to a non-party. A written request to admit, for the purposes of the pending action only, the truth of any matters within the scope of that rule. Again, this is that general rule that says things have to be relevant, but they don't have to be admissible. Relating to facts, the application of law to fact or opinions, and the genuineness of any described documents. Again, these are the same things that we just talked about. So what is the form of a request for admission? Each matter must be separately stated. That's why we can't have compound requests for admission. A request to admit the genuineness of a document must be accompanied by a copy of the document unless it is or has been otherwise furnished and made available for inspection and copying. Obviously, you can't admit to the authenticity of a document that you don't share with the other side. That's kind of common sense. And what is the time period? Well, again, it's within 30 days after being served. And answer, let's look at what the answer looks like. If a matter is not admitted, the answer must specifically deny it or state in detail why the answering party cannot truthfully admit or deny it. A denial must fairly respond to the substance of the matter. And when good faith requires that a party qualify an answer or deny only part of the answer must specify the part admitted and qualify or deny the rest. So you have to be very precise in how you word this, in other words. The answering party may assert lack of knowledge or information as a reason for failing to admit or deny only if the party states it has made a reasonable inquiry and that the information it knows or can readily obtain is insufficient to admit or to deny it. And again, typically this language is literally cut and pasted. There's no need to reinvent the wheel. If you're basing a particular action on wording from the Federal Rules of Civil Procedure, go ahead and cut and paste it. Now, you don't have to put it in quotes. In fact, usually people don't put it in quotes. There's no perjury associated with borrowing language from the rules. That's not a concept that we have in the law. Let's look at the objections that a person might advance who's responding to requests for admission. The grounds for objecting to a request must be stated. The party must not object solely on the ground that the request presents a genuine issue for trial. Motion regarding the sufficiency of an answer or objection. The requesting party may move to determine the sufficiency of an answer or objection. Unless the court finds an objection justified, it must order that the answer be served, that an answer be served. On finding that an answer does not comply with this rule, the court may order either that the matter is admitted or that an amended answer be served. The court may defer its final decision until a pretrial conference or a specified time before trial. Okay, so that's when maybe there's an issue about whether that answer really does everything it needs to do in order to resolve that. If again, if it's somewhat ambiguous as to whether it really resolves that issue. So let's look at an effective admission. What happens when something is admitted? A matter admitted on this rule is conclusively established unless the court on motion permits the admission to be withdrawn or amended. So again, most of the time it's going to be established forever, but there's always that loophole. The court can, at its own discretion, its own decision-making process, look at that differently. The court may permit withdrawal or amendment if it would promote the presentation of the merits of the action. If the court is not persuaded it would prejudice the requesting party in maintaining or defending the action on the merits. An admission under this rule is not an admission for any other purpose and cannot be used against the party in any other proceedings. And again, we already saw that for purposes of this proceeding only. We've already seen that. So let's go back to our PowerPoint. So now we are tasked with the job of preparing requests for admission. There's probably a little bit less boilerplate with requests for admission when you're drafting them than there would be with some of the other topics, because you're really going to have to dive into the facts. I mean, you probably are going to have a standard request for admission for authenticating a document, for example. So there's going to be some that are boilerplate, and there may even be some common themes that you see, but you really do need to kind of tweak the language to reflect the particular fact pattern that you're working with. You'll be using the same format that we've used for our other written discovery requests, and you can find that in part 2. You know, we'll have the caption, we'll have a title, we'll have a preamble, we'll have a definition section. We really don't need to have an instruction section. The Federal Rules of Civil Procedure pretty much functions in that mode. Then you're actually going to have the request, and you're going to have a subscription and a certificate of service under those circumstances. So what types of requests are you going to be looking to draft? Well, they're probably pretty intuitive at this point, the things that you're going to look for. You're going to look to see facts that are going to help your client win the case. And again, these may be facts that are pretty uncontroversial, but just simplify the issue trial. Or they may go to those key issues that you know they will deny, the other side will deny if they remember to put them in at a reasonable time. The facts that are undisputed, again, it may save you from having to call some witnesses and tie up the precious time that you have in front of the jury. And again, the authenticness, the genuineness of documents. You're going to want to limit each request to a very specific fact. You won't want to compound it. You'll want to have it just focus on one particular fact. That means that you'll have a pure answer, because if you say, if it's a more complex thing, more complex set of facts, and the other side denies it, you won't be quite sure exactly what they're denying. I mean, they ought to separate things out, but maybe they don't. And so you ought to be very careful to restrict it just to the one fact. Here is our caption. Nothing different about this than the caption we've seen again and again. Here is our document name. You can see we have the party. We have the number that this one is, it's the first one, and then we have the title of the document. There might well be additional ones because, again, we're not capped at a certain number. And then we have who it's sent to. Again, it's going to be sent to the client, but through the attorney. And then we're going to have our preamble. Defendant Burt D. Bandit serves these requests for admission on plaintiff Buford T. Justice as authorized by Federal Rule of Civil Procedure 36. Plaintiff must serve an answer to each request and separately and fully in writing within 30 days after service. No big surprises there. Then we have our definitions, and you can see these definitions you can cut and paste from other requests for admission, or possibly even from your interrogatories or document production requests. Definitely these will be rolled out again and again. You want them to be broad enough so that they cover everything that you want it to cover, but more than broadness in this situation, you're focusing more on the precision of the language. You were focusing more on broadness when you're talking about interrogatories and requests for production, but here you want a lot of precision. And here we have our request for admission, and here we have 5 examples. Let's look at it. You can see this first one is going to the truthfulness of a particular fact. At the time of the accident, you were not wearing corrective lenses. Okay, well, we have the term accident is defined. If we flip back here, we can see it's defined by number 3. The accident shall mean and refer to the automobile accident involving plaintiff and defendant occurring on this date at this location in this community. Okay, now you can see in the statement, there's no statement that you, again, that's another defined term, had prescriptive corrective lenses at all. Maybe you don't need them, but you still weren't wearing them, right? Of course, if you were wearing them, whether you needed them or not, then you'd have to deny this. But if you, in fact, weren't wearing them, whether you needed them or not, you would admit to this allegation. Number 2, now we're going to prove up a document. or that's what we're attempting to do if we're the one who is sending out these requests for admission. The document attached to these requests as Exhibit A is a true and correct. This is a term we see. It seems fairly redundant, but people always say it. True and correct copy of your driver's license that was in effect at the time of the accident. So this may be used to show that, hey, look, this person had a restriction. This person wasn't supposed to drive without his contacts or his glasses in. That may be what it's going at. There may be some other issue that's going at. Who knows? But that seems to be perhaps what we're building on here. Request number 3, again, we're going for the truthfulness of fact. The speed limit on West Houston Street where the accident occurred was 20 miles per hour. Again, another truthfulness. At the time of the accident, defendant was driving at a speed slower than 20 miles per hour. Number 4, at the time of the accident, defendant was on his way to work. And now here we have a difference. We're now applying the law to the facts. No act or omission of defendant relating to the accident constituted a breach of defendant's duty of care to you. Okay, so this is one of those foundational things. I mean, if accidentally the plaintiff were to admit to this, it's hard to see how the plaintiff is going to win the case. He's going to deny this. I don't know what his basis for denying it is going to be, but he's going to have something to go on from this perspective, or the case is probably going to be over. We have 2 examples of requests that are improper. The first one is it's just going with the law, so it's not applying the law to the facts, but it's just looking at the law. Under Texas law, plaintiff seeking exemplary damages on the basis of malice on the part of the defendant must prove malice by clear and convincing evidence. This may be true, this may not be true, but you can see there's no application of this legal principle to the facts of our case. And so therefore it's not something that is appropriate for a request. And number 7 is also improper because it's compound, it has more than one fact. At the time of the accident, defendant was not using a cell phone. Okay, that would make a good request, so we could put a period there and we'd be fine. We could have a separate one that says at the time of the accident, defendant was keeping a proper lookout. That would make another request. But because they're in the same one, it's compound and it's not appropriate. That in and of itself can be the basis of an objection. And now we have the signature phrase. I don't actually have in this one a certificate of service, but we would obviously need that in here as well. So we'd have the certificate of service after. So let's pretend, though, that you are not the person who's propounding the interrogatories, but you're the one responding to the request for admission. Let's see how that's going to work. Okay, so you are a paralegal who is representing the person who has just been served with the request for admission. What are you going to do? Well, the first thing you're going to do is you're going to calendar the date. And you're not just going to calendar 30 or 33 days in the future. You're going to have several stopping points along the way, because obviously you don't want to just wake up in that morning and say, oh my gosh, they're due today. And that's the first time you thought about it since you were initially served. You're going to want to do substantial work on it over the course of those 30 days. And then, of course, you're going to want to share it with the attorney and also with the client. After you've done those 2 tasks, you're going to want to start looking at each one of the definitions and each one of the requests to determine what objections, if any, you're going to have. And you probably are going to have some. Then you're going to want to talk about to what extent each one of the statements can be admitted or denied, or whatever basis that you might have in that area. And then, of course, you're going to talk to the client. Some of the facts you're probably going to know that we're going to admit this one, we're going to deny this one, this will be our basis. But there may be other facts that you aren't sure about, and you need to reach out to the client and get the client's opinion and evaluation of facts for that particular allegation. So at this point, after you've talked to the attorney and you've reviewed the documents, you're now prepared to draft some proposed objections. Again, you're likely to use some previous responses to requests for admission that you've prepared or that someone else in your office has prepared as a starting point, so you're not reinventing the wheel. If you have to, if you don't have access to something from your law firm, then you can go to some form books that would include that information. And if you don't have access to those, then you can look to the actual Federal Rules of Civil Procedure and kind of cut and paste that language so that you are as close to possible parroting what the rule requires. So once the attorney has approved that initial draft with all of your responses that you think are appropriate and he's made whatever changes are reasonable, then it goes to the attorney to, not the attorney, the client, to make sure the client agrees. And then once you've gotten everybody's agreement and you finalize the documents, it doesn't have to be verified, so there's no need for a notary signature. And of course, the reason you don't need it to be verified is that if something is admitted, it's admitted. There's no need for verification. If it's denied, I suppose you could have, the Federal Civil Procedure could have taken the position that you needed to actually have a sworn statement to deny something, but it's not necessary. Although you aren't supposed to deny statements that you appropriately should be admitting to. And again, you're going to send that not just to the party who has propounded the discovery, but to all of the other parties if they are not represented, and if they are represented, to their attorneys of record. So let's look at the objections that you might be making. We've already talked about the first, which is that the request is compound. It actually, instead of being a single statement, includes more than one statement. And the second one is it's a pure proposition of law. Things that are invalid objections are when you say, this presents a genuine issue for trial. In other words, I want the jury to decide this. I don't want to be put in a position where I have to admit or deny it, which usually means you'd have to admit to it, and you don't want to be put in that position. The fact that if you deny it, it would be a genuine issue for trial doesn't mean that you have the right not to answer the question. And you also, an invalid objection would be that this is not admissible in evidence. As we've learned in Rule 26, the scope of discovery is quite a bit broader than what is admissible into evidence. The question is going to be, is it relevant? Or is it reasonably calculated to lead to the discovery of relevant or admissible evidence? So let's look at the 4 responses that you can make in response to a question. That you may have had an objection, but now you're getting into the response. Well, of course, the first is admitting the request. That seems pretty obvious, and you're probably going to admit to some, because again, authenticating documents, confirming people's birth dates, confirming the date of the accident or the location of the accident. I mean, a lot of that's pretty obvious, pretty safe to admit to. Then there's probably going to be some that you're going to deny that you say, oh no, we didn't cause the accident or whatever. There may be some that are a hybrid, that you're going to admit portion of it and deny others. Now that may sound like the question might be a compound question, and it might be, but there may also be some aspect to it that even though it's not a compound question, you could admit to portions and not. For example, it might be a defendant's birthday is June 14th, 1974. Well, he actually was born June 15th, 1974. I suppose you could deny it, but what you could instead do is just admit that he was born in June and that he was born in 1974, but deny the particular date. You aren't expected to break that down into 3 statements. Admit that defendant was born in June, period. Admit that defendant was born on the 14th day of the month, period. Admit that the defendant was born in 1974. You can bundle all those 3 things together. And then you sometimes have a situation where you cannot really take a stand. You just don't maybe have enough information about that particular issue. For example, let's say that you are the defendant and you send a request for admission to the other side saying, admit that the defendant was born on June 14th, 1974. Well, how can you admit that you weren't there when the defendant was born, but you can't deny it? I mean, it seems probably likely. I mean, given what he looks like and what you know about his background, that seems like about the right time. But under those circumstances, it's really not something that you're in a position to admit to or deny to. So here's the language that you might go with. If the reason that the responding party lacks sufficient knowledge or information to admit to deny the request, or if the reason is that the responding party lacks sufficient knowledge or information to admit or deny the request, the party must state that it has made a reasonable inquiry and that the information it knows or can reasonably attain is insufficient to enable it to admit or to deny. Again, that's straight from the Federal Rules of Civil Procedure. The birth date of the other side, that would be a classic example of this. Okay, obviously you're going to want to dissect each one of the requests and make sure that there isn't anything that you're accidentally admitting to that you want to deny to. That's one of the reasons I use the strike-through feature, or I write it, or I print it out and literally strike through stuff as I have addressed that. And whatever is left that I haven't struck through, I make sure that I address that. And so if you do it this way, then you can go back and say, oh, wait a second, I haven't handled this particular fact. So this is an example of what your response might look like. As you can see, it's just like all of our other captions in this case. And we have the name. Now it's the plaintiff who's filing this response. And then we have the name of the document. Since there's no need to file more than one objections and answers for any given set of requests for admission, there's no need to say first or second. We have again who's getting it, and it's not being sent directly to Bert, it's being sent to his attorney of record. And we have our preamble here. Plaintiff Buford T. Justice serves these objections and answers to defendant Bert D. Bandon's first request for admission in accordance with Federal Rule of Civil Procedure 36. And then we dive into our objections, and you can see there'll be objections possibly to the instructions or to the definitions. Again, here, I don't think we actually showed instructions in our request for admissions, but you certainly could include instructions if you wanted to. And here we have our answers, and you can see the answer is just as simple as this. Obviously, you're not going to put it in bright red here, but you just deny it. Here, you're going to type up the request just as it is in the initial document. You can type it up, or you can ask somebody in the office to type it up. And at the time of the accident, you were not wearing corrective lenses. Well, you're denying that. You're not saying you needed to wear them or you didn't need to wear them. You're just saying at the time of the accident, yes, in fact, you were wearing corrective lenses. You might have been wearing somebody else's corrective lenses. Maybe you're nearsighted and you're wearing someone's corrective lenses who are farsighted. I mean, that could be the case. Then we have an admit. In this case, we're not dissecting it. We're saying every single part of this is true. So let's say you agree that this is a true and correct copy of your driver's license, but it wasn't the driver's license that was in effect at the time of the accident. You renewed your license 2 months after the accident. Well, you would admit to this part, and then you would deny this part. At the time of the accident, defendant was on his way to work. Well, you're the plaintiff in this case, right? And so how do you know what defendant was going to do? Defendant knows what defendant was going to do. And so that's something you're probably not going to admit or deny. And in this case, we didn't admit or deny. Defendant cannot admit or deny because after reasonable inquiry, the information defendant knows or can readily obtain is insufficient to enable it to admit or deny. Defendant is the party who has personal knowledge relating to this request, and plaintiff has not yet had a reasonable opportunity to conduct discovery to obtain sufficient knowledge to admit or deny this request. And then we have another one. This because it, we have our objection. Now, technically, when you make an objection to a question, you don't have to deny it. But I think attorneys are a pretty cautious group, and usually people will go ahead and deny it. So defendant objects because the request consists of a pure proposition of law, therefore deny. Defendant objects because the question is compound, therefore deny. And then we have our subscription. And again, you would have a certificate of service after the subscription. And now we're flipping back. We're now associated with Carrie Fogg's office. We have just gotten back the answers to the requests for admission. So we've gotten all of the admits and denies from the other side. And now you are being charged with the task of reviewing that information. Okay. Well, one thing you're going to want to do is make sure that they were sent to you and received by you by the deadline. If they were too late, then all those denials they have may well have become admissions. You want to go through and look at the objections and see if they were reasonable or if they made objections that were not valid. See how those admissions and those denials and those objections affect your client's case. And also consider that with these admissions that we now have, Does this open up the possibility for a motion for summary judgment with more teeth, or at least, or perhaps a motion for partial summary judgment, or some other motion that you might be able to file? And let's look at a couple of motions that you might seriously consider after you have gotten the request for admission. One could be motion to deem matters admitted. So let's say that the responder has admitted portions and denied portions of statement, and you want to use that as an admission, but you want the court to determine whether that answer or that objection is sufficient to comply with the terms of Federal Rule of Civil Procedure. If it is sufficient, then the matter can be deemed admitted. If the response is insufficient, then the court can order that the other party serve an amended answer to that particular question once whatever the objection is resolved. So I make an objection, my objection is invalid, we'll say. The court then might say, well, because your objection is invalid, we're going to deem you to have admitted to that allegation. Or the court might say, no, your objection is valid, everything is cool. You didn't have to answer the question. Or the court might say, yeah, your objection maybe is a little iffy, but we're going to give you leave to go ahead and amend. And if you want to go ahead and deny the answer at this point, I'm going to permit you to go ahead and do so. So it's a way of resolving any of the outstanding requests for admission. Now, occasionally, a party inadvertently admits to something it wishes it hadn't, or perhaps it misses the deadline. And so now it's kind of throwing itself on the mercy of the court in the hopes that the court will allow it to undo what it has done. And so it can't just send an amended set of objections and responses. That's not going to do it. It actually has to file a motion with the court where it asks the court to allow it to withdraw or to amend its responses. It's really left to the discretion of the court whether the court is going to agree to this or not. The standard, we saw this in Rule 36, this is what the court is going to look to. Would permitting this action promote the presentation of the merits of the action? And, so this is not an or situation, the court has to find both of these are present. And would this action, with this alignment amendment, would it not prejudice the party who served the request for admission and maintain your defending the action on the merits? You know, if there's been a tremendous delay between the time of the initial filing of the request for admission, not filing, but serving of the answers to the request for admission, and the other side has been working on the assumption they can treat all of these that have been admitted as admissions, and now on the eve of trial, you realize you admitted something you ought not. Well, it could be that the other side has really planned its strategy around those admissions, so it would be prejudiced. On the other hand, if you're just a day late and you're still well before trial, then the prejudicial argument's pretty weak. You're still going to have to, so you're probably going to be okay with the prejudicial argument, but you're still going to have to show that allowing you to amend would promote the presentation of the merits of the action. So we're done. We have covered requests for admissions. If you have any questions, please bring those to class. I'll be delighted to answer any that arise. Thank you for your attention, and I hope this has answered the questions that you have about requests for admission.